The panelists, who are also some of this year's Excellence in Advocacy Award winners, will discuss special issues associated with representing youth with disabilities, changes in the system they would like to see implemented, issues that keep them up at night, and some of the most creative strategies they have used in representing children with disabilities. Come with questions, as panelists will take questions from the audience. And Mary Kay will introduce the rest of them. And before I turn it over, I just wanted to acknowledge we had the 2 year ago Judge Gladstone Award winner here as well with us the last 2 days, and that is Judge Jill Walker. Thank you.
Good afternoon, everyone. I want to first recognize the Excellence in Advocacy winners statewide. And so what I'd like to do, when I call your name, if you could please stand up. And for the audience, if you could refrain from clapping, we'll give them a big round of applause once I've gone through all of the names. So I'll start with our statewide winner, who is also on this panel and from the 11th Circuit, and that's Robert Latham.
Do I have to stand?
You do. You're the statewide winner. From the First Circuit, okay, hold your applause till we're all done. He's the statewide winner, so I'll let you guys do that. But okay, Susan Winterberger from the First Circuit, Stephanie Johnson from the 2nd, Heidi Kemp from the 3rd, Connie Bird from the 4th, Brenda Smith from the 5th, Bowdry McAllister from the 6th, Carol Kelly from the 7th, Nancy Wright from the 8th, Barbara Glass from the 9th, Deborah Wells from the 10th, C. Michael Kelly from the 12th, Scott Horvat from the 13th. Scott, just wanted to comment, Scott was actually supposed to be on this panel with us today, and he had a family emergency that necessitated him leaving unexpectedly early from the conference. Lawrence Cranert from the 14th, Penny Martin from the 15th, Richard F. Joyce from the 16th, Linda Singer from the 17th, Pamela Bress from the 18th, Crystal Marsh from the 19th, Kathy Bruno from the 20th, and Leonard Helfen from Appeal. So if we could all give them a round of applause. Okay, you can sit down. You can sit down. I won't make you stand the whole time.
Thank you.
So now I'd like to, it's an honor to introduce our distinguished panel, and I am going to give you just a little bit about their background so that you have a good idea of where they come from, what brought them to be here with us today. I did ask them each to give me something interesting about themselves that's not on their traditional bio. So if you hear hopefully you'll be able to figure out what those things are. So Heidi has been advocating for the rights, and I'm going to introduce Heidi Kemp first. Heidi has been advocating for the rights and protection of children for over 10 years. Heidi graduated from the University of Florida and the Walter F. George School of Law in Macon, Georgia. The first years after law school were spent in private practice, handling primarily family law and adoption cases. When Heidi joined the Department of Children and Families in 2004, her passion for child advocacy was born. Over the next 10 years with the Department of Children and Families and the Guardian Ad Litem program, Heidi would be involved with specialized cases with children to be adopted and teens in care. In 2015, Heidi opened her own law practice, which included appointment as attorney ad litem throughout the 3rd Circuit of Florida as well as the 8th Circuit. Heidi has lectured at the University of Florida College of Law and taught at St. Leo University for several years. In addition, Heidi is the fundraising director since its inception of the Superhero 5K in Gainesville, Florida. Alan had like a superior time in that race. I don't know if he's in here right now, but whose purpose was to raise money to assist in finding forever homes for children in foster care. Heidi has a lengthy list of hobbies that she aspires to, including reading more, traveling, knitting, sewing, etc. At this time, and any and all free time, however, is spent with her husband, 4 children, and 2 cats. She is a soccer mom, dance mom, baseball mom, school mom, scheduler, playdate, chauffeur, and cook. Heidi and her family enjoy Disney, Harry Potter, and trips to the beach and movies. Our next panelist is Robert Latham, and I think you can figure out which one's Robert. Robert is the Associate Director of the Children and Youth Law Clinic at the University of Miami School of Law, where he represents children and young adults in civil matters and instructs law students on child welfare, client representation, and seeking justice through law. His advocacy focuses on youth who need unique supports, including youth with disabilities, immigrant youth, and LGBTQ youth. Before joining the clinic, Robert was a senior attorney with the Guardian Ad Litem program in the 11th Circuit. Before that, Robert was a fellow with the Children in the Law Clinic at the University of Michigan School of Law. And before that, Robert taught Norwegian to American kids at Concordia Language Villages in Minnesota. He is neither Norwegian nor from Minnesota, though. Robert keeps a blog on Florida child welfare issues at robertlatham.wordpress.com because he thinks child welfare is really interesting and more people should be talking about it. And it is an excellent blog. If you don't follow it, I highly recommend you do that. I'm going to repeat it again for those of you who want to get your
Thanks
pen
for
out.
the plug.
It's
Thanks.
Robert Latham, and he works for the law school. It's not like he's making, this is not a paid pitch. So, robertlatham.wordpress.com. And our third panelist is Boudry McAllister, and she's been a practicing attorney for over 29 years. She's a native of Athens, Georgia, and she received her undergraduate degree from the University of Georgia, and then her law degree from Georgia State University Law School. Boudry had her own private practice in Henderson, North Carolina until 2007, where a vast part of her practice was representation of parents in dependency court, juveniles in juvenile delinquency court, and claimants in federal Social Security administrative law judge courts. Boudry formerly served as secretary and president of the Henderson County, North Carolina Bar, where she also represented indigent clients through Pisgah Legal Services and served as a mock trial team competition coach for local high schools. After starting her own solo practice in Tampa, Boudry's practice has concentrated on representation of disabled and incompetent persons in guardianship cases and representation of special needs attorney ad litem for children in dependency cases. Diligent and involved advocacy of children and young adults as attorney ad litem is Boudry's particular passion, and she was especially honored to receive the Excellence in Advocacy Award for the Sixth Circuit. Boudry now also enjoys representation of parents as private conflict counsel in dependency courts in the Tampa Bay area. She's also a part-time special traffic magistrate for the city of Tampa. She has 2 sons and is married to John McAllister, who is a retired U.S. Marine. In her spare time, Boudry collects, resells, and appraises antique and vintage dolls, vintage clothes, and antique costume jewelry. Boudry is a longtime member of several doll clubs and enjoys antique doll study and research. She has given many historical presentations at local, regional, and national meetings concerning various different types of antique and vintage dolls. After leaving dependency court or the home of a special needs child, you will often see Boudry hitting the local thrift shops, vintage markets, and antique mall shops in her area in search of wonderful resale items for her next antique market or doll show across the state. Okay, so with that, I'm going to, again, we encourage questions from the audience. Liz and Kelly have microphones out there. I'm going to start with some questions, just kind of get everyone warmed up. But as you have a question, just get their attention, raise your hand, stand up, whatever you need to do. So I want to start with just the basic question of what are special issues that are associated with representing disabled youth. And I'll start with you, Robert. I'll put you on the spot first.
Okay. Just in general. The first thing to know about representing disabled youth, and I think any kid in the foster care system, is that we have a tendency to get a little tunnel vision around Chapter 39. Chapter 39 for us is the end-all and be-all, but there are so many other legal areas that touch the lives of the families we work with that as lawyers, I think we have an obligation to be more fluent in. So for our practice at the University of Miami, we really strive to be a holistic law firm that can handle all of the legal needs of our clients. And that means disabilities benefits, that means school IEP issues and due process hearings, that means administrative challenges to rules that are holding our kids back, because sometimes it's the rules that are the problem. So from the legal perspective, the challenges facing disabled youth is that there's just so much out there that can both harm them but also protect them. And as lawyers, we really have to kind of move that towards doing better for our advocacy.
Heidi, what would you like to add to that on that topic?
Yeah, I just follow that up with all of those areas certainly need to be looked into, and it's something that I continue to strive for as I come across with a child that has different needs, different needs for their advocacy, whether it's school, whether there's something going on in their a criminal case or a delinquency case that may be there. They have a public defender, but sometimes you can be involved in that and really advocate for the child and that court to understand the disabilities, because often there's a complete disconnect between the two courts and they don't really understand what's going on there. And you can advocate for the child and his disabilities to avoid any kind of unfair sentences and kind of let that court know of what's existing.
Boudry, would you like to add anything?
I would just agree with them in that we're the gateway, and as the statute says, for all the different myriad of specific community services available for these children, and we need to ensure that they get all of those. And I also think we should be a positive support for them and uplift them all that we can. Let them know we're there for them. As an additional support person, I'm sorry.
Your microphone might
Look
be cutting in
forward.
and out.
Look
There-
forward versus,
Okay.
yeah, there you go.
There you go.
You don't have to look at us, we're good.
Okay, and just to be accessible to them, I had one of my special needs teenagers was being released from the JDC, the Juvenile Detention Center, and had been waiting there, 4 hours to be picked up by the CBC, and there was a breakdown. So luckily I have my cell phone with me, she called me, and I was able to get that taken care of right away. So, and we really need to be there for them.
Let's talk now about what the most creative strategy that you've employed in representing your youth. And if you can take a few minutes to get in the specifics of a particular case. And I'll start with you, Heidi, since I made Robert go first.
Well, that's a tough one. I feel like I've had many, I don't know that creativity, but I know that I certainly take things up a level. Things aren't working on a certain way, and I start getting different people involved, and I try different, reaching out to different people to get different resources involved, because I find that if one way is not working, that you need to try another way, and eventually one of these people are going to listen to you, and one of these people are going to find the right person, and it's just a matter of continuing to reach out, whether it's talking to the program director at a DJJ facility and figuring out what's happening in this case, and we need to get a staffing set up. Because if you just read on the paper what's going on with the child, it sounds really bad, but when you actually talk to the person, it's a totally different story. And I think it's a matter of stopping to look at the paper, but really reaching out to the people and just finding the right connections, because everyone is so busy. Everybody knows that everyone in child welfare is extremely busy all of the time, but it's a matter of taking the time to find the right person to get the attention that this case needs. So for me, just creatively, I just reach out to others until I find the right one.
Robert?
I mean, that's all you can do, right? Like, I think the people in this room, and I love speaking to people like all of you guys, because you're advocates, and you didn't sign up for this for it to be easy or to do it the quick and easy way. And so the most creative thing you can do is just to not stop. So the only thing I can add to that is when reaching down and around in your case isn't working, reach up. There are lots and lots of organizations statewide and nationally that need to know what's going on at the local level so that they can start pushing legal challenges and other advocacy and put pressure on either put pressure on agencies or create space for agencies to do the right thing, right? Because we often know that sometimes change just needs a little bit of help. So that would be my addition to that.
Okay, Boudry?
Yes, and I just wanted to quickly thank all my friends at the Sixth Circuit Garden Ad Litem program. They are a joy to work with. I've learned so much from them. They understand when I have a conflict and I've got to advocate for my client as opposed to their position, and I have learned so much from Mariella Olson and the whole team there. They're just fantastic to deal with. Please give them a round of applause. It's just been an absolute pleasure. They've been there for me every step of the way, and when they get exhausted in a case and I pinch hit, and vice versa sometimes if we're working toward the same goal. And you can learn all kinds of tips from these people and getting around in dependency court. One great tip I learned, I had a special needs autistic teenager in a really kind of bad warehousing type large children home. It was totally inappropriate. She was getting SIP placed, put in SIP place, put in Baker Acts like every other week. So filed a motion for change of placement, and just by putting in there that you're asking the judge to make the CBC file with the court 5 to 10 specific diligent efforts that they've made to change the placement of that child. They found a better placement real quick when they have to do things like that. So just learning the tricks of the trade can get you a long way sometimes where you want your children to go.
Heidi or Robert, do you have any tricks of the trade, as Boudry stated, that are specific examples from a case that you'd like to share where your advocacy was maybe something that was off the beaten path or unexpected?
I try to always be unexpected, so I have no idea. You'd have to ask the ones that work with me.
I traditionally, it's one of my character flaws. I'm more of a bull in a china shop, and I realize that does not always get me what I want. But I utilize others, and I know that I can speak with others to get the right person, and going up to maybe the CEO of the partnership or finding someone over at the state attorney's office who can, help me, because again, I lack a little bit of the finesse sometimes when I'm advocating because I'm a little bit overzealous. But you find the right people and you just connect with them, and they've assisted me in finding that right solution.
What are the changes in the system that you would like to see? And I'm gonna take off the answer more funding because that's the easiest and the obvious answer. But what other specific changes would you like to see in the dependency system? And I'll let you a practical change. And I'll make you go first this time, Boudry.
Oh, thank you. I've talked to many special needs attorney ad litem's and who have dropped off the list and that sort of thing because the private attorneys have to wait in dependency court so long for the hearings and judicial review. So I would just hope that the judges and magistrates would consider the cases where we're the attorney ad litem, if they could give us some kind of priority in those hearings. Because it's sad to see them drop off the list because they can't sit in court waiting 4 or 5 hours and they've got their other practice to deal with. That would be one thing. And with the older youth aging out, the judges and magistrates are rightly so putting pressure on us to have them set up under Chapter 393 and Chapter 744 guardianships, and they're tasked to do that now and to review that. So we have a hard time finding the guardian advocates or the guardians to serve, so it would be great if we could get support, hopefully that with the Office of Public Guardian, to have those children coming out of DCF care or foster care with special needs to take first priority with them, and also just more of a PR campaign to recruit more attorneys who will serve long-term as the attorney of record for these guardians, because the Office of Public Guardian will give them some priority, but they want assurance that there's going to be a private attorney that will continue to be the attorney for the guardian or guardian advocate long-term. And of course, they hesitate to do that just possibly for the rest of this person's life. So.
Heidi?
Like in divorces, children have the ability to talk about their preferences in the court, and there's little statute provisions that allow children to do that if they're of the right maturity, age, understanding. And I would really like to see that for some of our mid-aged youth who are involved in the system, that they can go ahead and provide that insight and their preferences as to what's going on and really be heard. We all have our roles. We're, voices of the child. We represent the children, but I think that, there needs to be a provision in there that really kind of gives some teeth to what we do within the statutes. I would also like to see a few more areas open up for the appointment of special needs attorneys, because I feel that we're missing groups of children that could really stand appointment. I volunteer for cases because they don't quite fit into the category where they can get an appointment, but it is clear these children should have an attorney. I watch them in court and I see like, oh, someone should be saying something, someone should be asking for the appointment, or it's so close, this child should really have one. So I'd like to see just broaden a little bit the ability to get some of these kids representation, because it is so important for them.
Robert?
I think just speaking broadly about the system, one of the things that really comes up a lot representing kids with mental health issues is that there are not always good services for them. We know that, right? And so what happens is well-meaning people try to make do with what we have. So as an example, you may have a child that is exhibiting a lot of behavior problems. None of them are criminal or juvenile delinquency in nature, but they're obnoxious, right? And so that's 35 placements they've been through. You've had 10 suitability assessments, and the suitability assessors come back every single time and say they're just obnoxious. That's it, right? You can't put a kid in SIP for that. And so somebody heard once that the kid smoked marijuana, and so suddenly I'm facing a Marchman Act proceeding, right? And it's like, okay. And I think it's well-meaning, right? I think it's well-meaning that we really need to help this kid in some way, so let's go to whatever resources we have. But that's not the right way to do it. And using kind of the last minute, last grasp of resources not only doesn't help that kid, but it also took a bed away from a kid who needed it, right? So I see that a lot. I would like to see that changed. Of course, it's a problem that's more long-standing, right? You've got to start now investing in those resources so that 10 years from now there's a place for the obnoxious kid to go, right? And there's a lot more beds for the kids with substance abuse problems, so that we're not having resource issues. So for me, just general community resources for me is one of the biggest issues that we could push.
And are there any statutory changes that Heidi, you mentioned something specifically regarding the giving more of a voice to the child in the statute, but Robert or Boundary, were there any specific changes in the statute that you'd like to see? Yeah,
I would definitely expand it. There's apparently more money than there are people using it, so why not, right? So that's first. I mean, I would say just expand it to all kids. If you need categories,
by expand it, you mean?
Expand so the special needs categories, for those who don't know, there are 5 categories of kids that do get attorneys appointed by statute, and those attorneys are then paid for by statute, and very importantly, their due process costs are paid for, because when you're pro bono, you also have to cough up the process server and deposition costs and all the discovery costs and everything else that you're doing. So the 5 categories are psychotropic medications, human trafficking, kids facing residential treatment centers, kids with developmental disabilities under Chapter 393, and nursing homes, thank you. And so nursing homes as well. And so expanding those to more categories, expanding it to all kids that need an attorney, just on a good cause basis would be great. Or to all kids if we have enough attorneys to go around. But if you were going to expand it, I'd like to see the kids in TPR proceedings have an attorney. I'd like to see, if we're going to prioritize, I'd like to see kids in licensed placements definitely have an attorney. Before kids maybe in relative homes, but I don't know, maybe that's not the right priority either. Kids in SIPs and group homes, definitely. These are kind of things that traditionally we see more problems with, so it would be nice to have attorneys for those kids. The other thing, if I can add a second thing I would like to see, though, I think we ask a lot of attorneys, and I train attorneys at the University of Miami. I teach in the law school, and wow, we ask a lot of attorneys. It's like they go to law school and then they finally figure out the law and then they practice for a long time, and then you're like, oh, by the way, to work in our area, you also have to be a social worker. And that's a big ask, especially from a lot of attorneys. So I think, I would like to see the statute change so that it's clear that funding for some kind of social worker or adjunctive person to the attorney to be there to help with all the social work stuff that needs to be done. So in the criminal context, this would be called a mitigation expert or mitigation specialist. There isn't an equivalent in the dependency context for attorneys representing people in dependency. And I know a few of you in the room have tried and not thus far been successful, but good on you for trying. But I would like to see there be more support for attorneys that really, it's hard enough to navigate the law, but then to navigate the family dynamics and all of these services and have to be an expert basically with an MSW to really be effective. I think that's asking a lot, and we could do better.
And I would just add, I know I'm just the moderator, but an idea I have too, in terms of expanding the statute, I think a great way to do that would be length of time and care. So the longer the child's, because it just seems the kids that are in the system, the longer period of time, those are the ones that really need that extra advocacy.
Well, and multiple removals, you know, you have kids that have had suffered that, they could really have that kind of advocacy.
Okay, Boudry, did you have anything to add in terms of statutory changes?
I don't know if it would be statutory, but what I find with my special needs children, I have some placed all over the state. You know, they're very hard to find placements, you know, appropriate placements for. And then when I go to that other local community I'm not familiar with, I don't know who the go-to person is for the for the specialized sexual therapy and things like that. And I know the medical providers have the websites, but that really doesn't give you really good information you need regarding possible evaluations, therapy, or treatment. So I don't know if the people in the know are in the guardian ad litem program in that circuit. So I don't know if there could be someone designated through them for us, you know, to call when we have a child, a special person we can call regarding services in that circuit when our children are placed there. And that often
They're
happens.
typically, I mean, hopefully everyone in that program office could help you, but there typically is someone in the office that's identified as the SIP placement expert, or, you know, has so you should always reach out to and you may want to start with the attorney. If you're an attorney, you may want to start with the program attorney.
Right.
Would probably be the best way. And if you know, I mean, when you're really busy and you have a huge docket, I mean, I know sometimes it takes me a day or two to get back on phone calls or emails. So usually an email is a great way to reach out to someone for those of us who are in court a lot. So, you know, and you remember, you can find anyone on the, on the Florida Bar website or the Guardian Ad Litem website. You can find folks through that too.
Okay, and then the only other thing I could think of regarding the children who have the SSI or SSDI master trusts, you know, I know we get the accountings filed with the court before every JR, but I wonder if there could be a change. And so it's hit or miss sometimes when I find out if they're looking at getting ready to exceed their maximum and we need to do a spend down. So if there could be a statutory change, if we file a notice of appearance and a request and accounting from them every quarter, and also to include any sub-accounts in that master trust, that would be helpful. Because I've just had a client age out, and I called down there to the CBC master trust supervisor. Oh, by the way, there's $12,000 in dedicated funds in the sub-account. It's like, oh, it would have been nice. So, and that would take more action from me too. I'm sure I could request that of them, but it would be nice to have that in the statute, that if we request for those records, they would be required.
Right.
To give those to us more often.
Certainly you could, if an accounting wasn't filed timely with the judicial review, you could, insist that the judicial review be continued to the next docket, if that was in the best interest of till you get that document. I know I've also had trouble on my cases sometimes getting those accountings. It's also, as Heidi and Robert said, a great suggestion is finding out who the person is who is in charge of that for your CBC. I know Nancy Wright in our panel yesterday talked about how it's so important, and you guys did as well, to make those human connections. And usually once you have a name and a voice and a person that also knows your name and your voice, you can make a very pleasant phone call and you can often get what you need very quickly. Can be a lot faster than filing something in the court. But if you've tried that route repeatedly, then of course remember, as attorneys, that's always a good option we have, is to file something with the court, because I'm sure, I can't imagine a judge would not grant a pleading that required that information be provided. And remember, just to throw another, we talked about this a little bit in my panel yesterday, but just to kind of add on to that topic, and I don't know that Travis Fincham is here today, but so he has there are several pooled trusts in the state of Florida, so you don't necessarily have to use his, but remember, those pooled trusts are a great tool for saving beyond the $2,000 statutory cap. And they're very simple to do. It's paperwork that has to be filled out, but they've streamlined it. They help through the process. It is not difficult, it's not a cumbersome process. So I highly encourage you to look at that for your kids that are going to spend significant time in the system, that do have a, have a master trust account where they have funds coming in every month. And of course, I know there's been lots of trainings that Deborah Schroeth has done at these meetings, and we have a lot of them on our website as well, about fee waivers. So you can actually also save even more than just the overages. You can do fee waivers and save significant funds, and that could be especially important for your children that are close to 18. So if you want to save as much money as possible for them before they age out. See, I knew I wouldn't be able to just be the moderator. Okay, so let's talk about the JAC, because I know that there are some people in the audience that might be thinking about doing ad litem work, but that's a very scary word in terms of you hear the headaches of getting paid, and how it's just, I've heard attorneys in private practice say it's just not worth the work. I'd rather do it pro bono than deal with a JAC. So let's talk about, is it really that scary? And then also, I want one of you, maybe Rob, someone to talk about how you can actually petition to be paid for additional work, because I know that people are not utilizing that, so.
Okay, can I start?
Sure.
All right, so the JAC, for those of you who don't know, is the Justice Administrative Commission. We affectionately call it the JAC or JAC. It's not a person, it's a thing, full of people. It's how you get paid, so you fill out invoices. The JAC is wonderful. For all of you JAC people in the room, you are wonderful, because you don't care about anything except whether I filled out my paperwork right? Which is great. So as long as I do my job, you'll do yours, and everybody gets paid, and it's great. Now, here's how it works for those of you considering this line of work. There's a flat fee of $1,000 per year on dependency cases. So you get appointed, and then your billing point is the next JR. So if you got appointed at a JR, ching, congratulations, you just made $1,000. Now, by contract, if you go about double, if you work enough hours to count for double that, there's a $75 an hour presumptive rate. So you're kind of billing your time at 75 hours in the background, in the back of your head at all times. If you go over $2,000 in hours, then you can bill an invoice hourly if you would like to do that. So at about $2,000 a year. So what is that? That's like 26 hours a year. It's like 13 hours. Yeah, so yeah, it comes out to about 26 hours worth of work a year. You can start going hourly. I do way more than 26 hours a year on any given kid. I do keep my hours because I have to for my clinic. I easily do that. So it's not actually that hard. So I brought a visual aid. You can't see it, but I want to show it to you. And I kind of want to show you what it looks like. This is my invoice. I did this for a client or a case yesterday. This is a real one, and this invoice is for $27,892. Because that's the amount of work I actually did for this kid for 2 years. Now at our clinic, we take the amount, we funnel it back into our clinic, and we use it for services for other kids. $27,892. How did I get this? How hard was it? Well, I have an app on my phone that I paid $5 for. I clock in and I clock out on my clients when I do work. I hit send an email to me when I need to do my invoice, and it sends me a nice little spreadsheet that's already JAC compliant. It looks just like the spreadsheet they want. So I've got my spreadsheet there. I print out my emails from Outlook, because I keep them in a little folder for that kid, and I circle the ones that weren't, internal administrative emails. Oh, look, there's another $5,000 worth of work right there, because there's tons of emails. And every single text message this teenager sent me is actually a huge conversation, right? This kid goes on run every other day. And how does he communicate with me? Does he pick up the phone? No, he doesn't. I spent for 2 years of my life staring at a small screen talking to a kid on run, right? And I use Google Voice, so there's a plug to Google, and it makes it very easy to print out my text messages. I bill the minimum rate, even though I know each one of these text message blocks was probably an hour of my life, if not in actual time, in emotional time worrying about him afterwards, right? I go ahead and bill the minimum rate, and that's another probably $2,000 over 2 years worth of just text messages with a teenager, right? So I say all this to say, look, this is not that hard. All I do is print out stuff that already existed, put it in a packet, and I know that they will approve this because they've done it before. So all you Jack people in the room, maybe you can give a shout out. And this is money that you can be using for other things if you so choose, or you can keep your caseloads down to a reasonable amount and actually spend the time that you want to be spending with kids. When you do the flat rate, when you just take $1,000, well, how many clients do you have to have? You have to get, I mean, let's be reasonable. You've got to get 65 new clients a year to make that work, or have 65 at any given time. Oh my God, 65 teenagers on run texting me all the time. I go crazy, right? So I show you this visual aid to tell you that you can do it too. Right? And you can get into this, and it can keep your lights on, and you can pay for your paralegal, and you can have an answering service if you so choose, but I use Google Voice, and you can do it. There is no reason to leave the money on the table, because it's just out there, and somebody's going to take it away eventually if we don't use it.
What is the app, Robert, that you mentioned?
Oh, I shouldn't give a plug, but if you search for Hours Tracker on the App Store, or whichever phone you use, I bet you will find it. And I bet it's actually called Hours Tracker. And it was the easiest one I could find, because literally you set it up and it's clock in, clock out. And when you clock out, it says, hey, what did you do? And you say, I talked to my client. I talked to my client, you type in all the time. And then at the end of the whenever, it's one button to do your invoice. Not that hard.
How long does it typically take to get paid from when the time you submit your invoice?
Depends on if you did it correctly. There is a court hearing involved, and in the 11th Circuit, we've got a really good system worked out with the judges. We have one day a month that's kind of like billing day, where the judges hear on rotation among the judges. They hear all of the fee cases. So it'll just be an afternoon, and it'll be a room full of attorneys who are there arguing their fee hearings. Jack appears by phone. It's super efficient to do it that way, as opposed to having to like sneak it into a calendar. And you wind up getting paid probably a month or two later, so you've got to kind of budget around that. But it's not too bad. And if you're flat rate, of course, you get paid pretty quickly. It's not that hard at all. And you can always bill flat rate until you later do your invoice, and they'll just knock off the flat rate amount from it, so it's not a big deal.
With the due process expenses that you referenced, does the JAC pay those directly, or you as the attorney have to front those costs and then you reimburse, or how does that work?
There's several ways to do it, and I don't want to be a JAC expert. I don't know if you guys, you've done it. Go ahead.
Oh, go ahead. You want me to do? Okay. Yes. What I do, especially with these children all over that are placed all over the state, is just keep track of your costs, your mileage, your tolls, that sort of thing, and then fill out the state form at the state mileage rate and submit that to them. It's pretty easy. My only thing is, in receiving correspondences from Jack, they are questioning my mileage and saying we don't have to pay it because you're traveling so far out of your county to go visit them. So I was hoping I would have a better response to that. I'll have a Pinellas County case, and I've got to drive down to Lake Placid or Naples to see them, and they don't want to pay me the mileage, and I have to do this long expose on, it's a Pinellas County case. I've got to go down there and see them, try to do that once a quarter. So I guess hopefully they'll be more receptive to that. That's an important part of our job. So, and then I explained to them, well, and from where I live, it's not as far from Pinellas down to these places, so it's really a shorter drive. So I just hope that they'll be a little more light and breezy concerning some of those issues, where we really do need to go see our children and at least get paid for our mileage.
I think
To and from.
your question about like psychologists and things like that for due process costs, Jack has contracts with tons of people, and if they don't, then it's not too hard for the psychologist or psychiatrist or expert to get a contract with Jack for the payments. It's just some paperwork on their end, and then it's a PO type system. You're not fronting due process costs to a psychologist. You're not working up the litigation on your own and then getting reimbursed later.
And same for court reporters.
Mm-hmm.
So just keep that in mind in terms of it shouldn't affect your advocacy.
Yeah,
abilities.
Jack has a very comprehensive website about all of the if-thens of getting paid. Some things require prior court authorization, like and a kind of a cap rate on the amount, so that your psychologist doesn't go crazy and do a $500,000 eval when it was really kind of a $5,000 eval. But a lot of things don't require prior court authorization, so it's good to know which those are. So you just go do your process server, and the process server will bill Jack later. You don't have to get a court order for that, for example.
Heidi, any experiences with Jack that you want to pass on or advice?
Well, I've learned a lot of things sitting here with the two of them and how much money I've probably not accounted for, but the labor of love, not about the money. Money's good though.
Money's good.
Money's good. It's a process. Sometimes I get mad because I get rejected and I realize it's my own fault and I should have done this or I should have done that or I didn't do it at the right time. But I mean, traditionally I haven't had any issues with it. I hear a lot of people get frustrated with it, and I know you have to set up this account and you have to do that, and it's a little tedious, but once you're set up, I've honestly had no issues with it.
Great. Okay, let's move on to issues that keep you up at night. And I don't know I'll let you guys decide who goes first with that one.
Runaway teens. Runaway teens. Teens on my caseload, teens that I have that no one knows where they are, and I wonder where they are and what they're doing and when are they coming back, and why didn't anyone tell me until 10 days after that they were gone? Did I just get notice that my child's on runaway, and do I have to call every day to find out if they're coming back in, and what kind of condition are they coming back in? Will they be pregnant? Will they be on drugs? Will they be hopefully not in the hospital? I mean, those things keep me up at night.
Well, and then I guess a follow-up to that, and I'll let you guys also answer this, but a follow-up to that is what strategies have helped you get through those moments in terms of dealing with those more problematic issues?
Well, I think that you learn to recognize a little bit more which kids are going to be those ones that are runners. You have, like you said, you've got your ones that you know are going to be running, and you know that you need to be in touch with them on a regular basis. Maybe set up a safety plan, make sure that they can text you for safety, let me know that you're okay, just touch base. That's the best way. Just keep an eye on the ones that you know. I mean, I've recently had one that I was not expecting, and I'm awaiting her safe return.
I'd just like to say bad placements. Oh, they're really great, good ones, but there are some bad ones, and it just, it really worries me, and I just try to get them out of there as quick as I can, and just reaching out for more appropriate placements. In our area, for some of my special needs children, I have really been impressed with our local APD group homes and the services that they provide to these special needs. So my hats go off to APD in our region over there. And I really try to work, for the children that have no other goals, to get them in that placement as soon as possible. I was telling one of my state attorneys one day I had been out to a rather bad children's home, and she was like, "How was it?" And, you start comparing them because you go to a lot of, SIP placements and foster homes, children's home, that sort of thing, and it was just all I could remember was the movie Jane Eyre, when she's in school and the little girl standing up on the chair. It was just kind of short of that, the really dreary placements that just kind of gets you down, and there's no wonder you've got children running, and anyway, and there are ways you can try to correct that, of course, but that worries me a lot.
What do you tell your clients when they're in a placement that is not a good placement, and they're telling you it's a bad placement? I mean, how do you counsel the kids in that situation?
Oh, just to be patient, and I'm doing everything possible to get you out of this placement. You go over the motion for change of placement with them, other possible placements in the area. You have to be the squeaky wheel with the CBC, and I wish we had more access to their potential placement roles, because with one child you can get them, one caseworker, you can get them moved the next day. Another one, it takes you 8 months. And it's just like, if I had access to for an appropriate placement for my child, I would be more than glad to start calling around and trying to assist the CBC to make this happen as soon as possible. So just a matter of just bucking them to death on that and keeping after that, and little tips, you know, in the court to try to get them to move that along just as soon as possible.
So I think the things that worry me are slightly different because I'm in a slightly different role because I'm both attorney ad litem but also work in the law school. The main thing that's keeping me up right now, at least, is this rapid expansion of this out-of-home care population that we are seeing. A lot of you guys are experiencing it drastically in your areas, and it's putting all kinds of pressure in all kinds of places. And so the placement issue is one great example of that. I've got so many clients right now where I have to have this conversation that Audrey described, and I'm going to tell you, I am sick of apologizing to kids about how crappy their placements are. I'm sick of it, and I just can't do it anymore. I can't tell them just hang in there another day because something will come available. It shouldn't be that way, and I shouldn't have to look at them and say, well, I know it's bad, but it's not the worst. Like, wait, what? That's the comparison? That's not the comparison. Well, you should be thankful. I've heard people tell my kids that. You should be thankful you're not where you were. They just want to go back to where they were, right? So for me, this expansion is terrifying me because I know that it's only going to make things worse, and we are not keeping up with it. So that's part one. Part two goes back to what you heard in the opening bio. I focus a lot of my work on kids with unique needs, so immigrant kids and LGBT kids, homeless youth, and I am terrified. What keeps me up at night is not the child welfare system and them, though that certainly is part of it, but what those youth are experiencing day to day in their lives nationally, in the conversations that are being had nationally, and just in their daily experiences in their communities. So we represent a lot of immigrant kids, and I am terrified for them. I am terrified for them that doing some stupid kid thing, right? Some stupid kid thing is going to wind up with them getting law enforcement involvement, and suddenly I don't know where they are anymore. Not because they ran away, but because they were taken, right? For my LGBTQ youth, I'm terrified that they're going to go to school and get the crap beat out of them again, right? Every single day. We could have the best foster care system and child welfare system in the world, but the world is not its best right now. And we cannot forget that we have to be focusing our attention not only just making what we do better, but improving their lives every single place that they go, because that's what it means to advocate for them, right? And so for me, I can't even begin. Can I tell an anecdote? In my community, I live in Miami Beach proper. It's not as fancy as it sounds. There was, I think 3 years ago, there was a police-involved killing of a teenager. His name was Rifa. That was his street name. He was a tag artist, and he was tagging the McDonald's down the street from my apartment. It was like not even in a McDonald's anymore. It had been a McDonald's. It was an abandoned building for all intents and purposes. The police came over to him and said, you know, what are you doing? And Rifa did what other teenagers would have done in that moment. Boom, he bolted. They tased him, I think it was twice, and wound up killing him right down the street from my apartment. And I went to the memorial service for Rifa. It was held a few weeks later, and there were his friends, his school members, schoolmates. There were lots of people there. There were community leaders there, and I did not see a single person from the child welfare system come. Why? He wasn't one of ours, but he could have been. That's what keeps me up at night. The kids that we are working with are facing pressures that do not just involve what we do in this room or the decisions we make, and are we protecting them everywhere that they are? That is truthfully what keeps me up at night. We are not serving their communities as well as we're trying to serve them. Sorry.
Well, and now that we know that you guys are all,
So the statewide winner. So the winner.
now that we know that you guys are up all night, that leads to the question of how do you eventually sleep? How do you prevent burnout? How do you keep, and all of you have done this work now for a significant period of time. How do you cope with the stress of representing these kids and be able to do it long term?
Oh, I have no
I'll
idea.
start with Beth.
Go ahead.
Well, I think by having a balanced life, and when I go to my antique shows and things, and I incorporate that in when I go all over the state. It's just an opportunity after I finish that business to go by and check out, get some resale items, which is my therapy in a way, and I enjoy that a lot too. I think just by the best thing you can do is just to really get wrapped around maybe not all the issues, but pinch hit on some of these issues and just try to focus. What I'm seeing with when I get appointed to a child, I really want to look at a special needs a child. I want to look at basically 3 issues that I try to focus on. If they aren't being addressed, possible SSI, APD benefits, and then the school resources, IEPs. You would not believe the children I get appointed to who have been in the system for years, who are completely eligible for these things, and these things have not been done. It's like, what's been going on here, with case management all these years? And you think I've got time to talk about my example?
Definitely, and I just want to reiterate, I want to make sure that everyone heard that, because I think that's such an important point, that whenever you come to a case, you're the fresh eyes to the case, and you do not assume that Social Security has been applied for, or a lot of times it's applied for, and it was denied and no one appealed. It's a shockingly high statistic. If Deborah's in the room, she'll know it. I think it's 85% or something of cases are denied the first time of application, and then they're granted like 90% of the time on appeal. So and the attorneys will do those. They can get paid on a contingency basis, so you should have no problem finding someone in your area to do those cases. So, and that's really important that you get that in place. The sooner you get that in place, the sooner you can start saving in a special needs trust, or you can actually do some long-term planning. Okay, sorry, Badri.
Oh, that's okay. I just had a client appointed to me who was turning 18 in 7 months from the time I was appointed, coming out of a SIP place. Another thing that, of course, keeps you up at night are the serious cutters and the serious suicide attempts, and them getting the services they need to deal with that. But anyway, so he came in, and so the Sixth Circuit Garden Ad Litem program, so sharp, we collaborated on that. What needs to be done quickly for this child? And no SSI eligibility. The boy has no family supports whatsoever in the community. All the rights of the parents have been terminated. So we looked at him, many psychological issues. He's done terrible in school. So we had to get, as far as for APD eligibility, that has to be established before they're 18. So we were on a really tight rope there. And so Garden Ad Litem gets together. Let's get that IQ test done first. We suspected that first. And you have to really review all the file records and all the medical provider records, anything you could look at in the file. That was done. So then we're 4 months out. That came back with a 79 IQ. So he wasn't going to get APD eligibility on that route. And so I had remembered from going to the IEP suspected Asperger's syndrome, and just myself having an autistic child. I said, let's get him checked out for this. We weren't absolutely sure. There was not really just only suspected in the file. We had a good IQ evaluator who was not a specialist in that, but said, I also suspect Asperger's syndrome, autism, from the way he acted in my evaluation. So we picked up on that. So we go to the next status hearing. We're talking about 3 months out from him being 18. 4 months from him being 18, and we said, we got to get this dealt with. So anyway, we had the specialized autistic evaluation ordered. We came back, I think, 3 weeks later. That's how bad this case was. The judge was saying we need to statuses and have staffings about every 3 weeks. So anyway, came back in, 3 weeks later, and the caseworker goes, oh, well, we can't get him in and find anybody to do this for another 8 months. And just, got that bee in my bonnet. I said, this ain't happening. This has got to be done before he turns 18. So I get on the horn and find a great, and beg. And everybody wants to help special needs kids, explain the situation. I finally found a doctor who would fit him in my area, who has a great reputation in the specialized testing. So you do that. And I'm talking about, that's 5 or 6 hours right there, calling around begging, because usually it does take 6 months to get something like that. You do that, and then you get on the email with the CBC. We got to get this POS approved tomorrow. Of course, that takes 2 to 3 weeks on the fast track. You bugging them every day. We got to get this done. We're under a time crunch. And then you do that, and this particular client, he was basically being Baker acted or on the run most of every week. So that they were evaluating SIP placements, but he was so close to turning 18, they didn't want to put him in a SIP. So we got the appointment set up for his interview. 2 were canceled. 1, he was on the run, and the other, he was in a Baker Act unit a long way away, and the POS didn't cover that. I'm like, this isn't happening. So we're talking about a month and a half out, and my evaluator has to get collaterals on this boy too. So I'm sorry, I just said, I called the Baker Act unit. He finally landed in a Baker Act unit, and I talked to the program director. I said, I have rescheduled him in with this doctor. We've got to have this done. They said, convinced them to release him early. I went and picked him up from the Baker Act unit to the evaluator to have that done in time. And of course, these evaluators are busy too. The psychologist was busy. Okay, we are a week out from him turning 18, so I'm calling my doctor saying, okay, where's this report? What's going on? And I get a voicemail saying, I don't think I can approve him. And you're like, why? So you get on the phone with her. She said, oh, he tested fine for autism spectrum disorder, significant, for the permanent. But I can't get my collaterals to call me back. So another great tip is this, and I found this my whole career. Everybody hates to go to court. So I start calling these collaterals, the therapist, the group home program director, all these other people. Of course, case manager, she had been in a car wreck, so I'm trying to get her in the hospital to talk to this doctor. And so I just got him on the phone and said, you need to call this lady back or you will be subpoenaed to court next week. And my judge was sharp enough to say, we're going to have all of them come in and explain why we can't get this done. And so, within 2 hours, all those people had called her back. She got her collaterals. We got it in 3 days before he turned 18. And the satisfaction you get when that APD application came back approved without even having to appeal it is just priceless. And I think if you can channel your energy into things like that, keeps you busy and takes off the stress, keeping you up at night. So,
Nice.
Okay. Who's next?
I mean,
Oh, wait, someone's waving their hand.
Oh, we have. I was going to let them answer their real quick. What are your stress releasers, and then we'll get to the questions.
I try to be very clear about how I define success. So success is not always winning, and that's hard for lawyers. Lawyers, Success is not always winning, sometimes it's fighting. And then with a lot of my clients, sometimes it's just counting the number of days that they still talk to me, right? And I think there's this misconception that lawyers just go around and fight for their kids, and we do, but we also have really tough conversations with them behind the scenes that you don't hear. And those tough conversations probably sound like the same conversations you're having with them, except they think that we're supposed to work for them. And so it's an awkward dynamic there. And so just have I managed to keep a relationship with that kid one more day? Sometimes, especially in my human trafficking HT cases, that is how I measure success. And if I get through the next day, hey, that's pretty good.
As a parent, I just feel like every day is stressful for so many reasons. And these kids on top of it, it's like, what do you do? And I, think about, like my kids and what they have, and it's this interesting dynamic. And I try and think of them as, I call them my other kids. I don't call them clients. They're my other kids, and I kind of think of them in that, not as a client sense. I think of them more as my kids, and that makes it a little bit easier for me to deal with because that's a very natural thing for me, and the kids are easy, and it's a little bit easier. I try, the more emotionally involved I get, which happens sometimes on certain cases, it can drain you, and I've learned that over 10 years. So you have to keep a careful watch on your kind of internal emotional attachment to your cases, because then you become less effective, you become too emotionally involved, and that's when you kind of have to take that step back, rethink. You find your coworkers, your people that you share ideas with and jump back and forth and kind of bring you back to like the center, and you kind of find that middle ground again, and you're back to being effective and doing the best job that you can for all those kids. I reach out to Mary Kay, I got Katie. There's plenty of people that you can turn to, take the stress off.
Support group.
Yes.
Okay, questions. I know Penny, I see her hand. Do you have the microphone? I need you to, if you can, wait for the mic, because otherwise you won't be on the recording, and then it's not fun to watch.
Thanks. After you're initially appointed and you have actually resolved an issue for the child for the reason that you got appointed, and I know I've been having cases for a long time, over a year, but when would you get off a case?
Never.
'Cause that seems like
Never.
Because you can stay on until the child's 18, just about,
And
because there's so
beyond.
many
That's what you
issues
do.
that come
You
up.
stay on until they're adopted, you stay on until they're permanent, you stay on until
Yeah,
whenever.
So under the statute, it says that you're appointed, but then you stay on until the case is closed or you're discharged. And I've gotten fired enough times to, that happens. But we stay on it until it's done. And then we have the benefit in our clinic that they can then retain us, their guardian or whoever, even them when they're an adult, can retain us afterwards, and we'll continue with them as an adult.
Okay.
Okay, I see, I can't really see with the lights if you're over here, but there's a question in the back. Or right, okay.
How do you determine how to advocate for a child when the child is very young and not articulate? And also, how does your role in this case differ from that of the guardian ad litem?
You want to try it?
I was going to say, I have 2 children, one who is in a skilled nursing facility, one who is 3 years old, 2.5. I clearly cannot have a conversation with a 2.5-year-old. She's got some, obvious needs, and she's not directing me what to do. We're not having conversations. You're reaching out to the foster parents. You're reaching out to the therapist. You're reaching out to the guardian. You're reaching out to CLS. You're finding every single person to get information, to try and figure out what's going on, because a 2 or 3-year-old isn't going to be able to assist you or be able to have a conversation. And a child who's in a skilled nursing facility, you're appointed because of the medical needs that are there. Again, a young child who cannot, have a conversation about her medical diagnosis, any awareness of it, any future treatments or anything like that. So it is difficult. It's one of those things where you talk to you get your collaterals, you find your peripherals, you get in touch with everybody, and you try and figure out what the best path is. And it's really kind of incumbent on you, because they're not telling you what they want, because they can't. You have to make your best educated guess from what you know about the situation. And you can't, the guardian, best interest of the child, our attorney ad litem, it really is more of what the child wants, which those 2 things are very divergent sometimes. And you can try and help your client understand what may be best, but when it comes down to it, a child wants to go home with a parent. It may not be what the guardian's saying is in their best interest, but that's what the child wants, and you can remind them why it may not be a good choice, but
I can answer it from the rules as well. So the rules of professional conduct for lawyers say that you're supposed to be diligent for your client and loyal to your client, meaning you're supposed to advocate for what they want when you can. And for clients with disabilities, this is very important. You're supposed to maintain as normal a relationship as you can with them. That's what our rules tell us to do. And so, and disability is defined both as cognitive disability or mental and physical disability, but also minority. So even our rules say that for a kid, you're supposed to try to maintain a normal relationship with them. And so when they're 17 and fully functional and on the honor roll and doing great, okay, you basically treat them like an adult. But of course, it funnels down to all the way down to the 1-year-old. What am I supposed to do? Well, the rules do say there does become times when you are supposed to act in a protective capacity, seek a guardian, kind of a guardianship guardian if necessary. But in child welfare cases, we've got lots of people running around doing best interest work, right? So I never really feel necessary to bring in a 12th best interest person. So in those cases, the lawyer kind of has to figure out for themselves what they're going to do. I think lawyers are in their best, or they're at their best when they are listening to a client and taking direction from another human being. I think lawyers generally are at our worst when we think we're right. right? And so it's anything we can do to make sure that we're touching base with that client. You know, the 3-year-old may not be able to say, you know, I have very strong feelings about the TPR of my parents, right? They're not gonna tell you that, right? But when mom walks into the room, she runs up and hugs her. Okay, I have something to work with as a lawyer there. Now, as a guardian ad litem, I may think that mom's horrible, right? But I know the kid loves her. And so as an attorney, I can put that information in front of a judge. This kid loves her, right? I can't tell you complicated things about whether my client thinks her mother's in compliance with her case plan, but I can tell you she loves her. Now, no lawyer has to be a lawyer, right? You can quit cases, you can drop off of cases and get discharged. So if it gets to a point where you can't actually do the work because it's so repugnant to you, whatever's about to happen, good God, get off of that case, right? You don't have to be involved in hurting a kid. Let that sink in, right? Maybe some other lawyer will do it, but hopefully not. I hope I can train everybody not to do that. There does come a point where maybe that kid just needs to be pro se, and we'll trust the judge and the system to work itself out. So I hope that answered the question.
Very good.
Still one in the back. Over there, I saw a hand.
First, I just wanted to thank the panelists for being here today and also for being such tremendous allies in the fight for best interests of children and for the rights of children. I wanted to draw on your collective wisdom and experience to get some guidance on what's a really frustrating facet of the law for practitioners. Children in licensed foster care who may have disabilities or significant mental health needs or just need certain types of accommodations, the quality and the nature of the specific foster placement is so important for outcomes and for the best interests of children. But as practitioners who are advocating for children, an obstacle we run into unless we're dealing with like a residential treatment type of situation is that dependency courts lack the authority to order a specific foster placement be made or that it be preserved if the child's already in one. Or at least they're not going to directly order that. It's a separation of powers issue. The department and the CBC seem to be holding all the cards, and so obviously we all spend an immense amount of time and effort doing what we can behind the scenes, so to speak, directly with the department, directly with the CBC. But what are your specific strategies and tips for bringing the power of the court, bringing the power of the judge to bear in terms of getting a child into a foster care placement that's going to better meet that child's needs, whatever they may be?
You want me to go ahead? Well, I think I talked earlier about filing that motion for change of placement. I mean, that's my best alternative when I need to find when there needs to be a change of placement. And I go ahead and state in my motion what that placement should look like. And like I said, with making the CBC file, 5 to 10 specific communications out or diligent efforts to try to change that placement within that week. I just also thought about something. It might also be good when you suspect there are placements out there and we don't have access to that information. You could also do discovery or maybe subpoena the placement person of the CBC to come in with all the daily runs of available placements that are appropriate for your child. That may be a good strategy as well, because I share the frustration with that.
I know in the 8th Circuit at times, the general magistrate there has done, just such that she wants to see copies of the reports and, who's got placements available, what kind of efforts are you making to look for placements for these children that, are appropriate for their needs and their age and everything along those lines. No one wants them sitting in that kind of group home kind of day. They go to school during the day and they spend the night there, but it's just not an appropriate placement. But your problem is, shortage of foster homes. Is this home going to be better than that home? And while you can bring them to court, you always wonder about the placement that you are going to end up with. Is it going to be better? Is it going to be worse? You get what you get. They change the placement, And is it going to be the right one for your child, or is it going to be worse? And I toy with that. You know, it's a very fine line. And a lot of times you make friends with the placement person. You know enough of the foster homes that you've seen them through the years. You know which ones are successful. You know which ones, and you figure out how to get to the top of the list to get into that home. Like, oh, how many children do they have in their home? Oh, are there any that are getting ready to leave? Oh, when will that be? And how can I get to the, you know, to be ready to take that spot? And it's being proactive for your child. That's not in court. That's the work that goes on outside of court, is having those connections and being able to get in there and do that. No one likes to be on the hot seat in court, and magically placements are found a lot of times before you bring them in to testify, but you know, hopefully you'll know what placement they're going to is the only concern.
Anything to add on that? Okay. Well, we are out of time. Oh, wait, Kelly, one more question. Sure.
Okay. The majority of my caseload are permanently committed children, and the majority of those children are on psychotropic medications. I know what the guardian ad litem is required to do in that instance and how we advocate. But as attorney ad litems, what do you do? And secondly, have you successfully opposed a psychotropic medication motion for your client?
Can I start?
Yeah, Robert's the statewide guru on this. So we're gonna...
let me tell you, from your client's perspective, they're super easy when you're an attorney. You sit down with them, you say, are you taking the meds? Yes. How do they make you feel? Better. Great. Are you objecting? No. How do they make you feel? Worse or no change? Are you objecting? Yes. How do you feel about stopping the meds right now? Oh, I'd like to do that. Let's go talk to your doctor. Doctor, is it safe to just stop the meds? Yeah. From our perspective, from a kid's perspective, all of this paperwork and stuff that goes on in the system, it doesn't really bother them that much. Whether their forms were filled out all, perfectly doesn't really bother the kid that much. As long as what the treatment they're receiving actually helps them and they feel better about it, then as their attorney, I feel good about it. Now, as their, as a lawyer with an obligation to the court and to do things legally, I follow up. But I try not to stress out about it a little too much. Now, have we had to fight on psych med motions before? Yeah, but usually the conversation you're having with the kid at that point is something on the lines of, okay, well, you can take this now, or we can be doing a SIP hearing in 3 months from now. Which would you prefer? I'll try my meds. I'll try them. It couldn't be that bad, right? So, you can get second opinions. The JAC will fund a second opinion psychiatrist for you. The statute does say that the court can order a second opinion, but sometimes you want a defense one that you kind of have in your back pocket, so you have somebody speaking to you so you know what it's going to come out as. So there are ways you can get it funded. This is a great example of when kind of a dependency specialist would be really useful for lawyers, because they would be able to have somebody they could go to say, well, what are the other alternatives? As a lawyer, I have no idea what the other psychotherapeutic interventions available in the community are, right? Who has time to research all of that? But if I had a social worker whose job it was to know that I could trust and talk to and give her or him confidential information about my client so that they could actually give me a recommendation that I can use, man, that would be great. So that's my answer.
Okay, well, I want you guys to have a minute before we start the next workshop. So if we could just give one more round of applause for this great panel. And thank you very much.